promotion of a company, and incorporation of a company.
Today we shall talk about the term promoters. Promotion is not just about film stars promoting their films. Companies too need promoters.
I wonder, given an opportunity, various kinds of companies each one of us would promote. If Mom had to promote a company, I'm sure she would start a company manufacturing alarm clocks. This would automatically wake up children without having parents banging on their doors. Interesting. Dad would promote a company that would manufacture earplugs with a unique feature. These would automatically get activated only when there were unreasonable demands from children. Hey, this is what I would term as creativity at its best. And what about our maid? She would promote a company that would manufacture robots to assist her in her household chores.
Promoter and promotion. Promotion refers to the entire process by which a company is brought into existence. It starts with the conceptualization of the birth of a company and also determination of the purpose for its formation. People who conceive the company and invest initial funds are known as the promoters of the company. What is promotion? Promotion of a business simply refers to the entire gamut of activities that are required to be undertaken for establishing a new business unit for manufacturing or distribution of any product or provide any service to the people. It starts with conceiving of an idea of how to commence business or by discovering an opportunity for the same. It also involves assessing the feasibility and viability of the same and then take the necessary steps to launch the business unit. The entire process of business promotion involves the following steps: ascertaining whether all the basic requirements such as land, building, raw material, machines, equipment, etc. are available or not. If they are available, one can assemble them, arrange the necessary funds, and set up the business unit to give shape to the initial idea of establishing the business. The entire process is called business promotion, and the person who does it is called the promoter. Classification of promoters. Promoters may further be classified as 1. Professional promoters, 2. Occasional promoters, 3. Entrepreneur promoter, and 4. Financier promoter. A quick look at the characteristics of each one of them. A quick look at various functions of a promoter. 1. Discovery of business idea. 2. Detailed investigation. 2A. Financial feasibility. 2B. Economic feasibility. Only when these investigations throw up positive results, the promoters may decide to actually launch a company. It is then that agreements are entered into with merchant bankers, underwriters and stockbrokers who are to assist the capital issue, and so on. 3. Assembling of resources. Assembling of resources is the next step if the project proposal is found feasible in the detailed investigation. The assembling function involves procuring the basic necessities for starting the business. Land, buildings, and such facilities may be secured at this stage. Four. Preparing preliminary documents. Promoter enters into preliminary agreements with parties before incorporation of the business. Preliminary agreements are mostly approved by the company after its registration. If the agreements are not approved by the company, promoters become personally liable. Memorandum of Association, Articles of Association and Prospectus are some of the essential documents according to the Companies Act. These documents should be submitted to the registrar company who has jurisdiction in the state in which the company is to be set up. Five. Naming the company. Promoters decide the name of the company and submit it for approval. Are you aware that a name cannot be selected at random? It's not just a few persons deciding on a name. There are several restrictions involved in selecting the name of a company. Let's go through them. A company cannot use the name of an existing company. It should not even resemble the name of an existing company. It should not indicate government patronage. The name must include the word or words Limited or Private Limited at the end. Once it is approved, the promoter can proceed with other formalities for the incorporation of the company. 6. Appointment of bankers, brokers, solicitors and underwriters. Promoter appoints the bankers, brokers, solicitors and underwriters. These appointments are to be ratified by the company after its incorporation. To conclude, promotion is an activity beginning with discovery of a business opportunity, which involves conducting the feasibility study, assembling the resources, and registering the business.
Sir, can we take a break?
How about after the lecture?
After getting the name approved, the promoter makes an application to the Registrar of Companies of the state in which the registered office of the company is to be situated for registration of the company. The application for registration must be accompanied by the following documents. 1. Memorandum of Association or MOA. Memorandum of Association is the most important document as it defines the objectives of the company. No company can legally undertake activities that are not contained in its Memorandum of Association. The Memorandum of Association contains different clauses. The Name Clause, Registered Office Clause, Objects Clause, Liability Clause, Capital Clause, Association Clause. Memorandum of Association defines the objectives of the company and states about the range of activities or operation. It must be duly stamped, signed and witnessed. 2. Articles of Association or AOA. Articles of Association contain the rules and regulations regarding the internal management of the company. It must be properly stamped, duly signed by the signatories to the Memorandum of Association and witnessed. 3. Consent of proposed directors. Apart from the Memorandum and Articles of Association, a written consent of each person named as a director is required, confirming that they agree to act in that capacity and undertake to buy and pay for qualification shares as mentioned in the Articles of Association. 5. The notice about the exact address of the registered office of the company. The same may, however, be filed within 30 days of incorporation or registration. 6. A copy of the name approval letter received from the Registrar of Companies. Statutory declaration. A declaration stating that all the legal requirements pertaining to registration have been complied with, is to be submitted to the registrar with the above-mentioned documents for getting the company registered under the law. This statement can be signed by an advocate of High Court or Supreme Court, or by a chartered accountant in full-time practice, or by a person named in the articles as a director. Payment of filing and registration fees. Along with the above documents, necessary filing fees and registration fees at the prescribed rates are also to be paid. The registrar will scrutinize all the documents, and if he finds them in order, he will issue a certificate of incorporation. The moment the certificate is issued, the company comes into existence. So this certificate may be called the birth certificate of a joint stock company. An in-depth view of some important documents. Memorandum of Association. Contents of Memorandum. Name clause. Objects clause. This clause is the most important clause of the company. It specifies the activities which a company can carry on and which activities it cannot carry on. The company cannot carry on any activity which is not authorized by its Memorandum of Association. Liability clause. This clause limits the liability of the members to the amount unpaid on the shares owned by them. Capital clause. Association or subscription clause. The Memorandum of Association must be signed by at least 7 persons in case of a public company and by 2 persons in case of a private company. The Articles of Association or AA contain the rules and regulations regarding internal management of a company. It is a contract between the company and its members, and also between the members themselves, that they shall abide by the rules and regulations of internal management as specified in the Articles of Association. It specifies the rights and duties of the members and directors. The provisions of the Articles of Association must not be in conflict with the provisions of the Memorandum of Association. In case such a conflict arises, the Memorandum of Association will prevail. A quick look at the contents of the Articles of Association.
What if the company does not have its Articles of Association?
If a company does not have its own Articles of Association, the Model Articles of Association specified in Schedule 1, Table A will apply. A company may adopt any of the model forms of Articles of Association with or without modifications. The Articles of Association should be in any of the one form specified in the tables B, C, D and E of Schedule 1 to the Companies Act of 1956. However, a private company must have its own Articles of Association. The important items covered by the Articles of Association include the following. This brings us to an important question. What is the status of a promoter? Is he an agent for the company? A promoter performs all the initial functions in the formation of a company, but he does not have the status of an agent of the company. A person cannot represent a company that does not exist. The relationship of principal and agent can begin only after the formation of the company. All the preliminary agreements signed by the promoter must be ratified by the company. Otherwise, the promoter will become personally liable to the parties to such contract. Promoter is also not a trustee of the company in the legal sense. However, he is expected to perform his job in good faith. Observed from the strict legal point of view, starting a company is the riskiest step a person can take. But if the promoter takes reasonable precautions while forming a company, there's almost no risk of the new company getting out of control and turning against him. The promoters have certain basic duties towards the company formed. He must not make any secret profit out of the promotion of the company. Secret profit is made by entering into a transaction on his own behalf and then selling the concerned property to the company at a profit without making disclosure of the profit to the company or its members. The promoter can make profits in his dealings with the company, provided he discloses these profits to the company and its members. He must make full disclosure to the company of all relevant facts, including any profit made by him in transaction with the company.
And what if the promoter does not disclose any relevant transaction?
In the event of a non-disclosure, the company can rescind the contracts and cover the purchase price paid to the promoters. Isn't that so?
Good job! The company can also claim damages for the loss suffered due to the non-disclosure of material information.
A promoter may be rewarded by the company for efforts undertaken by him in forming the company in several ways. The more common ones are: the company may pay some remuneration for the services rendered. The promoter may make profits on transactions entered by him with the company after making full disclosure to the company and its members. The promoter may sell his property for fully paid shares in the company after making full disclosures. The promoter may be given an option to buy further shares in the company. The promoter may be given commission on shares sold. The articles of the company may provide for a fixed sum to be paid by the company to him. However, such a provision has no legal effect and the promoter cannot sue to enforce it. But if the company makes such a payment, it cannot recover it back. The promoter is liable for untrue statements made in the prospectus. A person who subscribes for any shares or debenture in the company on the faith of the untrue statement contained in the prospectus can sue the promoter for the loss or damages sustained by him as a result of such untrue statement.
Gosh, the promoter's job seems pretty tough. He must be pretty glad that the company is all set and ready.
Says who? He has almost reached the end of the journey, but not the end.
Incorporation of a company is the next stage in the formation of a company. Incorporation refers to the registration of the company as a body corporate under the Companies Act of 1956. The following are the important steps in the incorporation of a company. Approval of name. As a first step for registration of a company, it is necessary to obtain the approval of the Registrar of Companies for the proposed name of the company. A set of 3 names are suggested in the order of priority. Once the name is approved by the registrar, it can be used for further documentation in registration. Filing of necessary documents. The following important documents are to be prepared and filed with the Registrar of Companies. 1. Memorandum of Association. 2. Articles of Association. 3. Statement of Authorized Capital. 4. List of directors with their names, addresses, occupation and age. 5. Written consent of directors to act as directors and their consent to purchase qualification shares. 6. A statutory declaration that all the necessary legal requirements for the formation of the company have been complied with. Registration fee must be paid along with the filing of documents. The fee will vary according to the registered capital of the business. At present, the minimum registration fee is 4,000 rupees for the authorized capital of 100,000 rupees. Registration. The Registrar of Companies, after scrutinizing the documents, will enter the name of the company in his register. This will be done only if the registrar is satisfied that all the legal formalities have been properly completed with. Certificate of Incorporation. After registration, the registrar will issue a Certificate of Incorporation. From the date of issue of the Certificate of Incorporation, the company becomes a distinct legal entity. The company can open a bank account and purchase property in its own name after receiving the Certificate of Incorporation.
At last! What happens if it is discovered that the incorporation of the company was invalid? Would that render all contracts with the company invalid?
Interesting question. The legal situation is that once a certificate of incorporation has been issued, the company has become a legal business entity, irrespective of any flaw in its registration. The Certificate of Incorporation is thus conclusive evidence of the legal existence of the company. For example, if the documents for registration were filed on 6th January, but the Certificate of Incorporation was issued on 8th January. But if the date mentioned on the certificate is 6th January, in such a case, the company comes into existence on the 6th and the contracts signed on the 6th January are considered valid.
What if a person forgets the signatures of others on the memorandum?
Don't worry, the incorporation will still be considered valid.
Thus, whatever be the deficiency in the formalities, the Certificate of Incorporation once issued is conclusive evidence of the existence of the company. Even when a company gets registered with illegal objects, the birth of the company cannot be questioned. The only remedy available is to wind it up. Because the Certificate of Incorporation is so crucial, the registrar has to be very careful before issuing it. On the issue of Certificate of Incorporation, a private company can immediately commence its business. It can raise necessary funds from friends, relatives, or through private arrangement and proceed to start business. A public company, however, has to undergo 2 more stages in its formation.
That brings us to the end of the lecture on incorporation. No, don't look so pleased. There's so much more to learn. This is just the beginning.
In fact, the beginning of the end for us.